I think we should probably move on to our next talk, which is the role of the civil surgeon. And it's my pleasure to introduce the next two speakers, Ms. Rosalind Brown-Frei and Mr. Bruce Larson. To begin with Ms. Rosalind Brown-Frei, she is currently working as a Policy Adjudications Officer at the U.S. Citizenship and Immigration Services, or USCIS, in the Office of Policy and Strategy. Her areas of expertise are grounds for inadmissibility or waivers, including health-related grounds of inadmissibility, matters relating to civil surgeons, unlawful presence and illegal entry into the United States, inadmissibility for prior orders of removal, and extreme hardship. As part of her work, Ms. Brown-Frei works on agency programs relating to her subject matter area, regulations, agency guidance, and information collections. She's been working with the UCLA since 2007. She also obtained her law degree from the University of Bern in Switzerland and a master's degree in common law from Howard University School of Law in Washington, D.C. The second speaker for the talk is Mr. Bruce Larson. He's a graduate of the University of Minnesota Law School and has been an attorney for more than 30 years. His career spans serving with the U.S. Department of Justice, as well as a private practice in Atlanta for 14 years and in-house practice for 12 years in the legal department of the Mayo Clinic in Rochester, Minnesota. His work has focused on immigration and administrative law and regulatory compliance. He now works with the USCIS in the Department of Homeland Security, also in the Office of Policy and Strategy. Mr. Larson's work primarily involves legal issues with permanent immigration and adjustment status, and inadmissibility grounds and waivers. So thank you, and please come up to the podium.
Okay. Thank you, Dr. Chang. Well, it's great to be with you all here this morning, and I can just sort of echo in part what Dr. Shin said, which is on behalf of the U.S. government, we are pleased and honored that, one, that you have the interest to be here this morning and want to hear more about this, and just, in fact, to thank you for the role that you do play, the very important role that you play as civil surgeons in the overall permanent immigration process. We could not do it without you, so thank you. The first few slides, and I'm trying to find what I'm doing here. The first few slides are, and I guess I would just say the role of the civil surgeon I'd like to add in context. We'll try to give you a little context this morning. Kudos to my colleague Rosalind, who is the actual author of this presentation. These are just a few slides that when you see you have printouts and so on. There's a few legal disclosures, you know, those lawyers. And the main thing perhaps is to say that please do not disseminate this without getting official approval from our public engagement folks at U.S. Citizenship and Immigration Services. Go ahead here. And before I just start, I'm going to take just a half a minute to say it was kind of funny as Rosalind and I were driving in from the airport yesterday to our hotel. She said to me, "So, Bruce, have you ever been in Los Angeles before?" And it gave her a kind of a vague answer because I wanted to save a different answer for this morning. But my vague answer was, yeah, I've been here before. I visited a few times. But what I didn't tell her, and she doesn't know, is that I was actually born in Whittier, which is nearby, Rosalind, okay? And I usually only tell that to people when I'm in California and I can say, yes, I'm a California native. So I share that with you this morning, and now she knows my secret. What did I have here? Oh, I wanted to also mention that we are going to be here at the conference all day, and we are happy to have you come up to us at any time and ask us questions or pull us outside the room or whatever. So we will be around for all the presentations, happy to speak with any and all of you as you may have questions and issues. So please approach us. Did I go back? Oh, so the overview. Very simply, we want to at least give you a basic background of immigration law in the permanent residence or adjustment of status process, in particular adjustment of status. We want to talk to you about the health-related grounds of inadmissibility. That may or may not be a term you're familiar with. Inadmissibility I'll talk about in just a moment. The roles of all of the different parties involved. In particular, the Form I-693 that presumably you are all familiar with, the medical exam and vaccination record. And we want to make sure that you have access to the relevant and necessary resources for you to do your work. So at the conclusion of this presentation, we hope that you will have at least a general understanding of the immigration process and how one gets permanent residence, or what you commonly hear people say, green card. And in particular, the people that you see are those who are seeking adjustment of status in the United States to become permanent residents. We want you to understand a little bit more about the purpose and the reason for having the medical exam, explain the different roles of the civil surgeons, USCIS, CDC, and the public health departments. And then, again, finally, to make sure that you can locate and use the resources that you need. So, first, I want to just mention, it's not actually on this slide, but important to understand is that the U.S. immigration system is kind of two parts. The one part is people who come here temporarily, and that could be people that are just visiting for pleasure, they're here on business, students, very large number of students come under a temporary, or what we call a non-immigrant visa. We have different kinds of temporary working visas and a variety of other things. So that's the temporary side. And then on the permanent side, we have those who are coming to actually live here indefinitely, ongoing, most of the time for the rest of their lives. And in order for people to do that, they typically have to be sponsored or have a connection with one of these four ways of coming in permanently. Either there's a family relationship, usually it's spouse, parent, or child. There's some kind of job sponsorship that is involved. Humanitarian reasons, most common for those would be refugees and also people granted asylum. And then there's a little thing called the immigrant visa, diversity visa lottery that some people come in on, not too often. But of these, there are subcategories within, in particular, the family-based immigrant categories and the employment-based immigrant categories that all have their different rules for eligibility and so on. And so the steps to becoming a permanent resident will depend on both the category that the person is applying under and also whether they're applying in the United States or applying while they're outside of the United States. So, I'm on to the right one. As you can see, this chart sort of explains the consular processing side. That's for people who are outside the United States and applying at a U.S. embassy or a consular post to get their green card visa, if you will, that they then bring along with them, and they present that when they enter the United States. Some of these people are just abroad. Some people, for various reasons, are not eligible for adjustment of status, even though they have been or might currently be in the United States, and so they have to leave to do the consular processing. And when they do that consular processing, they are examined by the panel physician that serves the functional equivalent of the role that you have as civil surgeons. For people who are in the United States and are eligible for adjustment of status to get their green cards, then they file the form I-45, the application for adjustment of status. They are, in general, most of them are examined by a designated civil surgeon as part of the medical exam. The completed form is at I-693. The statistics you see here from 2013 show us about a 46, 54%, a little more adjusted than consular processed. Historically, it's more towards a 2-to-1 adjustment of status versus consular processing. So the concept of admissibility. Before the late 1800s, anybody could come to this country from anywhere in the world, and there were no restrictions, nothing to keep them out. In the last 20 years of the 1800s, Congress for the first time imposed some standards for not so much who we wanted, but who we didn't want. So we made them inadmissible, as the terminology goes. And primarily, that involved health-related grounds. So back in the day, they called it a loathsome disease. If somebody was a criminal, the security grounds didn't come in till much later, but criminal grounds, and in particular, the early laws barred prostitutes from coming in. Public charge, we wanted people to come in who were able-bodied, were going to be able to earn a living on their own, were not going to be having to rely on the welfare system in order to immigrate. And if they had any previous immigration violations, we didn't want them coming in. So that's how the inadmissibility system started. So a process of who did we not want to be here. And with that, I think I'm going to turn it over to Rosalind to give you a few more specifics on how that all works.
So those are people we don't want here, right? And Congress said we do not want those people here if they have any kind of disease that is undesirable. And I guess you're all civil surgeons, so you know them well. They're communicable diseases of public health significance. Their failure to show that somebody has been vaccinated against a vaccine-preventable disease. It's mental, physical or mental disorder that is accompanied by some kind of harmful behavior, meaning it poses a threat to the safety, welfare, or property of the applicant or somebody else. And then drug abuse and drug addiction. So nowadays, Congress said those are the people. We do not want them here in the United States. And those are health-related grounds of inadmissibility. Anybody who is seeking a green card does actually need to be admissible to the United States, or they either are made go or they cannot become a permanent resident. Why did Congress have them? To protect the public health, and this is where Dr. Shin said, you know, it's so important, the role of the civil surgeon. It's really, you're the gatekeepers because you have the technical knowledge for us to determine, oh, this person could be a public health risk. As Bruce said, it has been around quite a while, since the first time was 1882, where public health grounds were considered. And although we say we do not want those people in the United States, it's really actually we want them to get well before they come to the United States. So the mechanism set in place by Congress is that if you are inadmissible, you can get a waiver. So once they see you, and if they for some reason do not want to comply with anything that is in the technical instructions, or if there is a condition that cannot be remedied, people can most of the time file a waiver. The one exception would probably be for the regular immigrants, that they cannot get a waiver for drug abuse or drug addiction, but there are other ways that they can overcome that ground of inadmissibility. And the key in most waivers that Congress put in place is that people actually get treatment. So it's not just we just exclude them like typically criminals are, where it's really hard to get waivers, but here it's really, we want you to get better. The health-related grounds of inadmissibility, Congress was wise enough to say that somebody else than DHS should really detail who should be let in or not, and the authority was given to HHS to promulgate regulations and to outline which conditions actually meet the 4 conditions listed in the Act. So this is the regulation here. The regulation go further. They say there are 2 types of conditions. There are conditions that are making really somebody inadmissible, or they're just conditions that may play another role in an applicant's assessment, whether they should come permanently to the United States. So HHS put in a system that says there's a Class A condition, and you know it well. It's on the Form I-693. And Class A conditions truly make you inadmissible. Somebody's diagnosed with this condition, they will need to do something about it. Class B conditions are typically conditions that are permanent in nature or that are serious in nature, that somehow inhibit the applicant from taking care of themselves or attending schools. An example is diabetes, for example, which is considered a Class B condition. Although it doesn't make an applicant inadmissible to the United States, it plays into what we call a public charge ground, is whether the person can actually take care of themselves because they have a condition associated with it that will likely subject them to public assistance. But there are many factors playing into that, and the medical is just one factor. So this is why we have the medical examination, because Congress says, please make sure that they don't have it, a Class A and Class B condition, and this is why you actually do the medicals, why people are coming, and why we at USCIS need the Form I-693. So HHS also detailed the regulation for us. So if you're a civil surgeon, you're bound by making that medical examination according to the regulations that HHS promulgated, and HHS gave technical guidelines exactly how to do it. It's the Bible for the medical grounds of inadmissibility. So it's binding on the civil surgeon. It's also binding on us at USCIS because it has the force of regulation. So it's our common document that binds us together and that really helps us assess and protect the public health here with the immigrant community. And of course, the results are annotated on Form I-693. The Form I-693 really kind of traces the technical instructions because it is so hard for us adjudicators to figure out is somebody, so we really rely on the technical knowledge. The forms finding are binding on USCIS as well. So I'm going to move over and talk a little about not just why we have it, but what are the various players within that medical examination. And of course, first is the applicant. So every applicant coming permanently to the United States at some point in time has an examination. Sometimes it happens outside the United States, just as like Bruce's chart showed. But for adjustment of status applicants, most really are examined by civil surgeons. They cannot get the examination outside the United States. So civil surgeons only examine those people who are getting the benefit here inside the United States. I listed a couple of categories. There are some exceptions. One of them is the refugee, and they, by regulation, do not have to get the examination, again, that they get abroad. But as I say, everybody has one. It's the applicant who ultimately submits the forms needed to prove that they're not inadmissible to the United States. So it's the applicant who submits the documentation. Often we get the question whether the civil surgeon should submit it, but it really is the applicant. The Centers for Disease Control and Prevention, as I said, they're part of HHS. They're the ones who are the expert on saying what conditions needs to be or inadmissible or health-related conditions that make somebody inadmissible. They are writing the technical instructions. But most importantly, they help us a lot at USCIS if we have questions. They're also available to answer your questions if you have any questions about the technical instructions. On the CDC's website and in the technical instructions, you can find information where to contact them. So at any time, if you have questions, medical questions, you're really not alone out there, you can ask CDC. So they also advise USCIS if we have questions about this I-693, we take it and we pass it by Mary Norton's branch. And most importantly, though, if somebody is actually inadmissible, we want to really make sure that the person gets the necessary treatment for the waiver to be granted. So the law stipulates that we have to pass any kind of waiver application for a medical condition by CDC, and they have to review the documentation offered by an applicant to make sure that actually the treatment is sufficient. So CDC plays a really big role in the adjudication of the immigration benefit for purposes of the health-related ground of inadmissibility, and we really lean heavily on them. So they answer questions. Civil surgeons, you all. So we designate U.S. Civil surgeons. That's our authority that we can do that. And the law stipulates that it has to be a licensed practitioner, MD, or a DO. And it needs to be, the person needs to be licensed where they're actively practicing medicine for the medical examination to be completed. They have to have 4 years of practical experience, and they need to be authorized to work. So non-immigrants, for example, who are temporarily in the United States but are authorized to work as physicians, they can become civil surgeons if they would like to. It's another question we often get. I don't know how many have been civil surgeons for more than 3 years in this room. So quite a few. So in 2014, we had a change in how we managed civil surgeon programs, and hopefully you got to see some of the changes. In the past, it used to be that somebody could become a civil surgeon by just going to a local field office at USCIS and saying, you know, I would like to do that. Here are my credentials. Could you be designated? And the local field office director would designate the person. Since 2014, we formalized the application process. We actually have an application. It's called Form I-910, and it actually costs to become a civil surgeon now. So if somebody is interested in becoming one, they fill out that form and they send it to USCIS. the entire civil surgeon program is managed nationally now. So everybody who was a civil surgeon was put into the central database, and from there on we verify every half a year that the civil surgeon is still actively practicing, and hopefully you saw the fruits of that program because we sent out letters asking for recertification documentation like, is your license still current? Are you still practicing? Would you like us to include website information on the USCIS's website where applicants can find civil surgeons? So this is kind of a new development. I cannot emphasize it enough. We ask civil surgeons that they go and read the technical instructions. It's really just the document that makes everything so much easier for the applicant, but also USCIS. So the CDC posts them on their website. They're really easy to find. You can Google them. CDC also has updates to the technical instructions, and I don't know, is there a sign-up feature? I'm not sure on CDC, but recently we had some development in the technical instructions. There were 3 communicable diseases that were removed from the list of conditions that make an applicant inadmissible. That was posted on CDC's website, and most recently there were new technical instructions posted for gonorrhea and gonorrhea assessment, which is also new. So CDC website is your resource. We want to make sure that the applicants who apply for immigration benefits are truly examined, and we ask civil surgeons for that reason that they check that actually the applicant that comes in front of them is the applicant who is going to seek the immigration benefit. And we want that the civil surgeon takes care of that throughout the entire examination, whatever it entails. So we ask civil surgeons to check the ID from the applicant. It needs to be a photo, government-issued photo ID. And to add that information on the Form I-693. So it's very important so that for any kind of follow-up examination, we don't want that the friend shows up or is just not the person. And then, of course, you have to report the result truthfully and accurately on the Form I-693. So those are the duties listed on form on the as being the duties for a civil surgeon. The technical instructions also ask that if a civil surgeon is not quite able to make an assessment, or if the technical instructions say so, that they make a referral to another physician. So it is always required if somebody is suspected to have TB, other than latent TB, they have to be referred to the health department. The civil surgeon needs to complete the documentation accurately according to the Form I-693 instructions. And then if you feel you don't have the technical knowledge to make a determination whether an applicant has a Class A condition or a Class B condition, then we ask you that you refer the applicant out. When you refer the applicant out to another physician, we also want to make sure that the paperwork is properly completed so that there's kind of a chain of custody, and that the physician, the person who receives the referral, makes sure that they check the fraud prevention measure ID checks, that the applicant that comes to them is actually really the applicant who seeks the immigration benefit. Even though you refer somebody out, it's always the civil surgeon who remains responsible for the completion of the Form I-693. So it cannot be another physician completing the Form I-693. It has to be you as the civil surgeon. In the past, we didn't have that on the instructions, but we ask that civil surgeons actually give a copy of the Form I-693 to the applicant. It's a medical document. It needs to be maintained just based on whatever law you're bound by as a physician. So just because you have the hat on as a civil surgeon doesn't mean that you take your hat off as a physician. So you have to comply with any kind of requirements, and part of it is that an applicant should actually get their medical documentation. I think on the other points I already kind of hit with stay current on the technical instructions by checking the updates to the TI. We also, since we centralized the program, we ask civil surgeon to notify us within 15 days of any kind of change that you have in a status, and it's at this email address here below. It's in the PowerPoint that was on the resource link for this training, so you can easily go and save that. As part of that is really we want to make sure that we manage. We have at the moment 5,772 civil surgeons, so we really want to make sure that if the applicant goes onto USCIS's website, that the information is current for civil surgeons, and that has been maybe a feature that is really new. Role of the health department. The health department is the department that you're going to refer people out, of course, for the TB assessment. The health department in general in immigration might have other roles because certain applicants for benefits have the right to get assistance from health departments, so that is one of the roles. And then most importantly, health departments can function as civil surgeons. If the physician on staff meets the civil surgeon requirements. We actually treat them slightly different to benefit the refugee population. It's also for the military population. They do not have to actively seek designation. We have blanket designated health departments who can just complete a vaccination assessment for refugees, for military physicians who can assist service members to do the medical examination. And because of the licensing requirements, sometimes for military physicians, that's kind of difficult. So we have blanket designations, but that's only for refugees. So anybody else who needs the full examination really needs to come to civil surgeons. And then us, USCIS, I think I touched on every point here. We adjudicate benefits applications, including adjustment of status. We verify that the applicant actually did get a medical by a civil surgeon, by a designated civil surgeon. If we are not, if we don't see it, we will go back to the applicant and send what is called request for evidence, and I bet you have seen those before. Our guidelines are in what is called the USCIS policy manual. It's available on USCIS's website. It outlines exactly what we're doing in what case. So if we find a deficient I-693, this is the research we go to, when should we send it, the request for evidence, and how should we treat those requests for evidence. And then, of course, we are designated by law to administer the civil surgeon program, and we also have our policy manual part about that, where you can read up on anything related to civil surgeons. It's a new resource, fairly new resource, but it's hopefully very helpful. A quick note on the importance of the I-693. It really is the document we will base our assessment for civil surgeons. We will base whether an applicant is inadmissible. So if an applicant comes to us and during an interview starts to cough and coughs really badly and spits up blood, we will probably say you need to go to a civil surgeon, because we cannot just say, okay, we think that you have some kind of disease. So we cannot make an inadmissibility determination without this document. So it's very, very important that it's accurately completed and that it's helpful for everybody if everything goes smooth. But it's our document and evidence. We gave you a snapshot. We also distributed some forms in the back, and you will need them throughout the day, so it will be helpful. The most current version is on USCIS's website. You always want to use the most current version, because we have to update our forms. We need to ask permission from OMB to post those forms up there. So every now and then they have to be updated and changed. And often we cannot accept outdated forms because of various requirements that we have to follow when we do those forms. So it's the best to not stockpile them. It's just hopefully to just get them out there. The Form I-693 is evidence of the applicant's inadmissibility, so it has a temporal period. It used to be validity period. It used to be that it was valid for indefinitely once it's submitted to USCIS. We had a policy change about 2 years ago that we said it will have a limited validity based on the medical findings. And the period is that the applicant has to submit it within 1 year of your signature that you completed the medical examination, and then we have to adjudicate the benefit within 1 year. If we're outside that period, the applicant will get a request for evidence and will have to redo the entire medical examination. That's kind of important to know. Summary on what the applicant goes through. I'm not going to go through this slide. And the next one is a slide with resources. So whatever I talked about, I'll list it here. Very important is also the civil surgeon designated civil surgeon webpage. On this webpage, we actually have contact information if you have questions who you should contact. We will not be able to answer any kind of medical questions. That would be CDC. We have CDC's information on there. But if you have any kind of question about the I-693, there is there's an email information on that particular page. I also printed it out if you need to look at it and how it looks like. On that page, we also have seminar information. So we have every quarter year, we're doing a civil surgeon seminar. We partnered with CDC on that. The next one is on August 10th. And if you're a civil surgeon, it's really helpful resource in there. So we have slides, and hopefully it's helpful. And I think that concludes my presentation. And if anybody has any questions, we are available the whole day. Yes, sir. Yes, you refer the case to that.
Protocol you usually will follow, or usually what do you do usually afterwards? If we see a TB case, let's say in the office, and we called you, what do you do? I mean, to our office usually.
So what do I do as USCIS? Or what do you do? So you will complete the... So Mary will be able to talk a little bit more about that, but what we really require is the documentation. So you would complete the Form I-693 according to instructions. You do a referral, you fill out your information, then the referral information, and you will send the applicant with that documentation. And the health department will need to complete it. I don't believe so, but that will be within the procedure of the health department, not within USCIS.
Well, I had one case. The health department came to our office and tested everybody, staff, even called a patient before that patient, after that patient. So is that part of the protocol or something?
The LA Health Department, yeah.
Why don't we save the medical TB questions until after my talk? I'm Dr. Naughton. I'm from CDC. No, that's not part of a protocol.
Yes,
so,
please.
Is my turn? Yes. Okay, I have a question about drug abuse and drug screening. If drug screening is one of the requirements, no, I'm sorry.
Actually, if we could go ahead and wait until Dr. Mary Naughton has her talk about medical aspects of TB.
What kind of ID are you talking about? Can it be like an outside of the U.S. ID, government issued?
It should be a valid government issue ID. If you're not sure about the medical or about the ID presented to you, just do the best. Use your best judgment.
I have a lot of patients that are Hispanic, and they bring their from their consulate or something. Is that a valid ID or?
So I believe it should be okay. I don't think it's I will double check, but any kind of valid ID should actually do, as long as it shows the face features, and you're going to put the information on there. So if in case of a referral, the applicant should really bring the same identification. If you ever have any kind of questions about the identification, we suggest that you make a copy and attach it to the back and just explain that this is the best that you could get from an applicant. If you feel like the applicant is really not the applicant in the ID card, we ask that you do not proceed with the medical examination.
Why was the HIV removed from the testing?
So that was one of the CDCs. That was one of the regulations that it used to be part of the HHS regulations specifying which conditions make you inadmissible. In 2010, or before in 2009, a regulation was published as a proposed rulemaking to remove HIV, and I deferred to Mary Naughton on the reasons, medical reasons for that. And then in January 2010, it was removed. So by regulation, it was removed. I would defer to the medical aspect of it, to Mary.
I think we have time for just one last question right here, and then you guys will have an opportunity to ask them more afterwards.
The validity of the I-693, you said it's 1 year, but we've been getting some patients coming back within 6 months, 8 months to to be retested. Is there a reason for that, or it's still 1 year?
So I suspect that one of the reasons why they were sent back is that we had to have a form update. So with a form, always there go other legal requirements into the form. And in last March, we had a form update and we gave a 60-day period. And then many civil surgeons did not use the updated form, and we really could no longer accept, or it just kind of played into it that we could no longer accept the forms where the medical was completed. So we had an announcement that many I-693s would come back and would have to be completed on another form. So it depends a little bit on the case. If you want to talk to me in person afterwards, we can maybe talk. But that was the reason last year where many I-693s came back. Mm-hmm. So the question is, why did the form, it used to be before 2008, it used to be 1 page. Why is it now 12 pages? Well, in part, we have new certification requirements that came in as part of the legal things. And then we also wanted to match the Form I-693 closer to the technical instructions, and so it became a little bit more detailed.